Welcome, everyone. Um, Welcome Tuesday, Aspire Talks. We're having our second talk today. It's Letty with Aspire Los Angeles. We are a boutique agency in LA. And today we're speaking with an attorney. Lalit Kundani is here. He is with, I'm gonna have to get my notes because I know, appreciation, KCKW law firm. And he is gonna be joining us today and talking about trust and estates, and we have a lot of good information for all of you available. I just want to point out that anyone can answer questions later on as well. So if you have anything specific to ask, just type it in the comments on social media or on the Zoom call if you have registered on the Zoom call, and we'll make sure that we answer those questions as well. And at the same time, we're also going to send you a copy of the recording once we're done with our information and Lalit's information as well. So if there's any follow-up questions, you know who to contact. So on that note, we'll get started. And Lalit, I'd love to have you introduce yourself for a minute as well.
Thanks, Letty, and thanks for hosting this meeting. I'm looking forward to speaking about these topics and answering any questions that folks have. But yeah, I've been a partner at my law firm. We opened up in 2014. I've been practicing since the past 15 years. And what I focus on is trust and estate planning. And so what that basically means is helping families or individuals set up plans to protect themselves and their assets in case something should happen to them. And I think one of the key things to focus on is, which we'll talk about today, is just to remember that if you don't do a plan, then there's a plan in place for us, and that plan is hosted, courtesy of the government, and it's not a very good plan to say the least. So, again, looking forward to speaking more about it.
Likewise. Great. So do you want to get started? Because I know you brought some slides. We're excited to see that, and maybe go a little bit more into detail about, what really estate planning entails, and just kind of the basic explanation of things.
Yeah, that sounds good. So what I'll do is I'll pull up some slides that we have about estate planning. And, generally the way I describe this to people is to think of an example. Because when we talk about estate planning, it's kind of nebulous of a concept, like what exactly is an estate plan? And I found that this is a useful analogy for many people to understand, which is, imagine like a ship that's set sail at sea, and you have the ship containing cargo. Right. And on board this ship is this very valuable cargo. And the whole purpose of the ship is now to deliver this cargo to its destination, right? So that's the example. And we're kind of no different in the sense that we are like, every one of us is like a ship in the sense that we have certain valuable items that we're carrying on board. And just to give you an idea, like these are the things that we generally, collect in our lifetime. We have property, we have bank accounts, we have, 401ks, we have life insurance or businesses or bank accounts, so whatever it is. And so this is the cargo that we're carrying. We are all carrying this cargo. And the whole purpose, and by the way, this is called your estate. So when we say estate plan, this is what the estate means. The estate is referring to all of your assets. And it's also important to also remember this, that we have other things that are very valuable as well, not just our assets. We have our children. We have our legacies. And what I mean by that is, it's one thing to pass down, Letty, your house. It's one thing to pass down your assets and your bank accounts. Right. It's another thing really to pass down something that you typically don't think about being passed down, which is your legacy. And what I mean by that is your values, your experiences, a way to teach the next generation the things that you have learned in your lifetime. And that's also something that we can do in a really good estate plan. And then something that's, I think, very unique that people really should remember about what it is other than just your assets that we're dealing with is your digital assets. So this is really important, especially nowadays, as you know. Right. We take photographs all the time on our cameras and we upload it somewhere to the cloud. But we need to remember what happens if I'm not around anymore. How do my children see their photographs online? How do they access their videos of when they were a kid? Because I
never thought about that, but very true. Yeah.
Yeah, and the problem is it's all password protected, right? And if you really want to think this through, which again, I don't think most people think about this like how we do. Of course, we think about this because we plan for it. But it's really interesting because I've had families tell me, oh, it's okay. I just will write down a list of my passwords.
Mm-hmm.
And when I pass away, I'll give that to, my kids. Well, the problem with that, of course, is one, your passwords change all the time. It's
Right.
probably not practical to make sure you capture all of that. But number two, we know this thing called two-step authentication or two-factor
Mhm.
authentication, where even if you have a password, sometimes if it doesn't recognize the computer, it's going to send a code to your cell phone.
Yeah.
So really, people need to have a really good plan for this, not just your assets. So it goes way
Right.
more than just your assets. So anyway, the point is, what is an estate plan? It's a way for us to ensure that we can make sure that everything that you have, all of these things that we talked about, is safely going to go to the people you want it to go to.
Right.
Not just the assets, but everything else. And the problem, and we'll get more into this later, but the problem is that just like this picture, if you don't create a plan that's safely going to do this, you're going to run into this big thing that looks like an iceberg. And
Right.
this iceberg is made up of all kinds of things, right? Like all of these problems that can come up if you're not prepared for it. And the way the system is set up is we are all headed for this iceberg. It could come at any point, but
Right.
we're all headed for this iceberg, and we have to face these problems. So
Mhm.
that's what estate planning is. The estate plan is working with someone to make sure we go around these problems in the right way, so that we're not going to run into these issues. And that's usually the analogy I give to people.
Right. Okay. Makes sense.
So I didn't know if you wanted me to keep going, but I
Yeah, no,
guess.
keep going. I think it's good to kind of get a better understanding about what really estate means and what it entails.
Okay, so again, when we look at these problems that can come up, like again, using this analogy, what's
Right.
beneath the waters or beneath the surface, we have probate. Probate is something that everyone really should know about, because it's most of the time it's going to affect just about everyone.
Mm-hmm.
And what it is, and I guess we can talk about probate. So what is a probate? Probate is this court process that occurs when you pass away. So if I die, my assets have to go through this thing called probate. And in California, the limits are very low for probate, which means that if you own a property and that property value is $55,000. So now, Letty, I can ask you this.
Yeah.
I'm not sure of any property out there that's worth less than 55,000, but
Not in like LA County.
right. So for most folks, that's why I say if you're a homeowner or you own any kind of property, and by the way, it doesn't matter how much equity you have. The way probate works is they look at the fair market value of the asset in order to determine if there's a probate. So that's why 55,000 is really low, because it's not equity, it's just the value.
Mm-hmm.
And then they say that if you're not a homeowner, so for those folks who just who rent, who haven't purchased a home of any kind,
Mm-hmm.
then they look at how much you have in cash assets. And they marked it says 166, that's meant to be 166,000. So if you have 166,000 or more in cash assets, then there's a probate. So it really, a lot of people get affected by this when they pass away because the limits are so low. And this is what it is. The judge gets to decide who gets your assets. But before that, and this is the most important thing, before the judge decides that, there's this whole process that needs to take place where your creditors have to be handled first. Okay, and that's the reason why this probate is so bad in California, is because this creditor issue takes a long, long time. Generally, it takes about 1 year to 2 years, in my experience, for most people who have a home and some assets. And it takes that long because there's a lot of things in California that we have to go through. We have to go through an administrate, you have to get a court date, first of all, which takes a few months. You have to do a publication in the newspaper. You have to be appointed by the court. So that means that someone in your family who's going to be the executor has to pay money, put up a bond sometimes to do this. And then all the creditors have to be notified. This is like your mortgage company, the utility companies, your credit card bills, your hospital bills, your student loans, right? So your IRS payments, right? Because you still owe taxes even after you die, by the way. So all of these things have to be handled, and it takes a really long time. And
Sorry.
during this,
It's
Sorry?
like just being at the forefront of some probates on the real estate side. I've seen people just also have such a hard time personally, because here you want to mourn the person that you've lost, and now you have to deal with all this administration, and it's even extended in time and in complexity, because you have to deal with all these extra things. So I've seen families just fighting with each other, a lot of disputes happening just because things are not set up correctly, and you have to depend on a judge right now that's gonna basically decide how you're gonna have your family, assets be divided. So it's a very helpless feeling, I feel.
Absolutely right. And during this time, generally, for at least the first 6 months or so, the assets are more or less frozen. In other words, families aren't able to access the bank account to pay for things. Families aren't able to do a refi on a property, or even, get access to some property. So everything is slowed down and to a fault. So you're absolutely right. And it's very expensive. That's the other point I wanted to make here, is that, somewhere between 5 to 15% is usually the minimum average. So even you call it like 10%, that's a lot. And if you took 5% on what's counted as $1 million estate, that's $50,000. So it adds up very, very fast. And this is in addition to whatever the family is going to pay to the creditors. So the creditors might take a lot of this, and you have these court fees. Right. So after all of this is done, which again takes a year or two maybe, then at this point, the judge is able to decide who's going to get what, right? So now he's going to determine who's going to get what. And that's why I have this picture of a shredder, because that's what it is. It's like probate is like a big shredding machine. It's going to just kill everything that you've earned. And at the end of it, you might be left with some scraps. And it's these scraps that are going to be going to whoever is left in your family. And now the judge is going to need to know who to give these scraps to, right? And that's when the will comes in. So a lot of people say, oh, I just need to do a will. If I do a will, then my life's going to be, my family's life is going to be great. But no, because even if you did a will, the only purpose of the will in California, if you have a probate, is the will is just going to tell the judge who to give the scraps to. Whatever's left over from the probate after a couple of years, if there's assets still left over, it's going to go to the people in your will. If you don't have a will, like some people just don't even have a will, then the judge gets to decide who's going to get what's left. So they'll follow the state law where the property or the assets are in. So really important to remember that a will does not avoid a probate. I think this is a big, big misconception. And again, this is state specific. So I'm really focusing on California, and the way a probate works in California is that if you just did a will, you're still going to end up with a probate. Okay, that's one of the key differences between a will and a trust. Okay. So then that really leads to the next question, which is what exactly is a trust? And the way I've explained it, again, I always try to use analogies that people might find easier to understand. Is let's say I'm just walking around with everything in my hand. Like as a kid, we're running, like my daughter, my 2.5, she loves to run around the house everywhere, right? And we tell her to pick up her toys, and she picks up all her toys in one little scoop, and then she runs, and then she'll fall, and everything scatters all over the place. And this is why I say that's probate. That is exactly what probate is. Probate is where you put everything in your name. Your house is in your name, your bank accounts are in your name, your properties are in your name, your brokerage accounts are in your name. And when you pass away, it's going to go everywhere, because that's what probate is. Everything scatters. It's going to be a big mess. Now, a trust is very different. What a trust is think of it like a wagon. If I told my daughter, put all of your toys in this wagon and just pull the wagon, now if she falls, which she's gonna, we, to use the analogy, we are all gonna fall at some point. We're gonna hit that iceberg. But when that happens, our assets don't have to go all over the place and get lost. Yeah. They're still in that wagon. And so if for folks who understand a little bit about how this trust works, they may have heard the term a living trust, okay? Revocable living trust or a living trust. So this is how it works. I create a trust, it's a document, okay? If you're individual, in other words, if you're single, it's just you are the author of that trust. And if you're married, it's going to be generally the two spouses. In California, we do joint trusts, and you're going to do one trust together. And the trust is going to have a name associated with it. So, we'll put the Jones Family Trust as an example. Now what we do, once the trust is created, now we're going to take our toys, right? So in my house, it's Barbies, but in some other houses, it might be G.I. Joes, right? But you're going to take your toys, and these are your assets, and we're going to retitle. Now, this is the important thing. We have to retitle these assets into the name of our trust. So we have to now take our house, take our bank accounts, these are the toys, and we're going to move the title into the name of the trust. Okay, so that's my fancy animation. That's as fancy as I can get, but now it's in the trust. Okay, and I wish it was that effortless. So it's going to take a little bit more work to move it, but it's not too complicated. We're just really going to retitle the assets by name. So we're going to go to the banks, we're going to go to the county, and we're going to retitle the assets so that now the Jones Family Trust owns all of our assets. Now the cool thing is that if we pass away, somebody can still pull the wagon for us. The wagon, we're going to build directions so that now I'm pulling the wagon. Tomorrow, my trust is going to say that this person's going to pull the wagon. And so then these are the terms that we use. We use something called the grantor. That's of a trust. That's the person who creates the trust. The person who wrote the trust, that's the grantor. So if it's a married couple, it's the husband and wife. It's a single person, it's that person. Then you have somebody named the trustee. That's the person pulling the wagon, gets to decide, where everything is going to go, basically. That's you. You are the trustee, you are the grantor, and you are the beneficiary as well. So you are all three of these people when you create a living trust. And again, it just means that as the grantor, you get to rewrite and change the trust. As the trustee, you get to pull the wagon and decide what to do with the assets. And as the beneficiary, it means you can take your toys out and do whatever you want with them. Mm-hmm. But the key is that when you pass away, your trust is going to say who is going to be the next trustee, who is going to be the next beneficiary. And so that's as simple as it is. As long as everything is in your wagon, in the name of your trust when you pass away, there's no probate. But if things are in your name, then there could be a probate. So that's the example I give to people. Hopefully that, that kind of better explains the concept.
Makes sense, for sure. No, I think that's very helpful to know. I think that we kind of covered the difference between a will and a trust. There was one question that came to mind for me as well, and I know we kind of discussed this, but what documents do you need if you become incapacitated?
Okay, great. So in a situation where, so a trust is really useful to think about, like we said, in probate, where I pass away. But if I don't pass away, that's your question. If I don't pass away and I become incapacitated, and this is really, timely of a conversation, given what's going on around us with, the COVID pandemic, right. Which is that, unfortunately, a lot of people who were being treated became incapacitated, whether they were intubated or put into a coma. But during this period of time, obviously they're incapacitated. They can't make decisions. Now, what happens in a situation where their house needs to be sold? Mm-hmm. Well, if they're a joint owner with their spouse, even the spouse can't help because it requires two people to sign off. Or if there needs to be a refi, or something needs to be signed on their behalf. And also medically, like what if the doctors need to speak to this person, but they can't? So now they want to speak to the family, but HIPAA, there's this HIPAA rule that says the family members can't really speak either. So what do we do if someone's incapacitated? And so let me just see if I can jump to this slide real quick. So this is what we do. We create something called the power of attorney. Mm-hmm. And the power of attorney is a document that says that if I become incapacitated, the power of attorney lays out who can make financial decisions for me. Mm-hmm. And I have a similarly, something called a healthcare directive, which lists out who can make medical decisions for me. So by me having these documents in my estate plan, then my family members or whoever I have named can make those decisions for me. The good part is they don't have to go to court now, because if I don't create these documents, the rule is always very harsh that now my family has to go to court to get permission. They have to pay money. They have to do an accounting. They have to take all of these steps that are completely unnecessary had I just created these documents ahead of time.
Mm-hmm.
Okay. And there's another document called the HIPAA authorization, which again allows for people to speak to your doctors and get information if you are incapacitated.
Right. Okay. Sounds good. Thanks for answering that.
Yep. And so another thing that I wanted to, I'm just going to back up here. Another thing I wanted to talk about was just sort of the benefits of a trust. So we have the ability to avoid probate, as I mentioned. We are also able to help our whether it's our children or our beneficiaries, whoever they are, we're able to protect them from a lot of other things. For example, one of the downsides of not having a trust is that once my kids get my assets, they can do whatever they want with it, right? It's not unheard of that, especially when you have a probate. Unfortunately, in a probate, not only do you have to deal with all of the mess that a probate causes that we talked about, but you also have to deal with this reality is that when your child turns 18 and you're in a probate, the judge is going to hand over full control of the assets to the child at age 18. And we see a lot of children make really, really bad decisions. You know, they might sell a property that's really not something you should be selling. They might be withdrawing the entire retirement account when they should just be letting it grow tax-free. You know, they may not decide, they may decide, hey, I don't need to go to school. What's college? I got millions of dollars, and they realize just how quickly how short that lasts. So a trust is able to not only avoid the probate, but it's also able to make sure that we write down how our kids and when our kids are going to get our assets and in what way. So it's just controlled in a much more responsible way. And, you know, there's other examples that we can protect our children from. If they got a divorce, or if they got sued, or if they had disabilities, the trust will be able to protect them from that. Depends on how we design the trust. So that's really important to know, is not just avoiding probate. And then the other thing that I'll just mention is with minor children, you know, because this is another question that people have is, what happens if I have minor kids? You know, so probate and the trust is there to make sure my assets don't go into probate, fine. But what happens to my actual children? Like, where do they go when I pass away? And this is the question I think a lot of parents have always asked themselves, at least multiple times, right? Which is, gosh, what happens to my children if I don't come home today? And what's really important to understand is that, and I mean, I can tell you stories. In fact, there was a situation where my old firm, the firm that I used to work at, represented the family members of a married couple. They were named the Barber family. They were from San Diego. And they went on a family vacation. They went on a road trip to Arizona. And during the road trip, their car overturned, and unfortunately, both the mom and the dad died. Now, in the back of the car were the three boys. They were all under the age of 10. The youngest was 3 and the oldest boy was 8, but there was 3 of them. Now, they survived, luckily, but the problem is there was a big custody battle over the boys about who was going to raise them. And for a period of time, the boys ended up in temporary custody because people couldn't agree on what was going to happen. And these things take time. So really, you don't want to take a chance. If you have minor children, part of your estate plan is not just to create the trust, not just to create the incapacity documents that we talked about, but it's also to make sure that we name guardians for our kids. And the way that would look, you know, in our office, this is kind of what we do. We have people name both temporary and permanent guardians. And the idea behind that is you don't want your children to be in temporary custody, so you name temporary guardians, and you want to make sure there's no fighting among relatives or friends, so you want to name permanent guardians. And then we can do a lot of other things to protect the children even when they get injured, just to make sure there's no court involvement unnecessarily. It always leads to more money. And this way, at least parents have some peace of mind that, okay, I get to decide who's going to raise my children.
Right.
And in our office, we also do these things called identification cards. And this is just an example of one. We obviously changed the names here and the phone numbers. Those are not real numbers, so I can assure you those are just made up. But the idea being, we want to carry ID cards in our wallets. If we have young children and something happens to us, this ID card will notify someone to call these people, these temporary guardians, in case something happens to you. So there's a lot of different pieces when we do guardianship, but this is again something that needs to be part of your plan if you have someone under 18.
Yeah, that makes sense.
Yeah. All right, and then this is kind of like the other topic, which is lawsuits, right? So, and this comes up quite a bit, especially for folks who have businesses, Letty, like, you know, some of your clients, I'm sure, who have rental properties. So anytime you are conducting business of any kind, even if it's through a rental model, or if you even have employees or you have like brick and mortar stores, you have to be concerned about a lawsuit. You just have to. The numbers speak for themselves. I'm not going to give the statistics today, but I think the numbers as far as even California are concerned are so alarming in terms of the number of people who get sued at any point in their lifetime. And it's really important to make sure that, you know, we part of our plan, we have in our estate plan something that deals with what happens if I get sued. So is there a way for me to protect myself, protect my family, protect our assets, so that this person who's suing may not come out and get everything? And there's obviously, you know, again, different ways this happens. You could be driving a car and get in a car accident and get sued because you injured someone. You might be a surgeon or a doctor who is what we call more of a high risk profession, where the chances of you getting sued are greater. You might have, like we said, businesses or rentals. So some of the strategies, there's a lot of different strategies we use here, but the idea is, you know, what are some of the things that we can do to protect ourselves or make it better if we do get sued? One point I want to make real quick is, a lot of people say, well, I want to do something where I cannot be sued. Okay, that doesn't exist. You can't ever come up with something where you cannot be sued. Mm-hmm. You can't stop someone from suing you. Okay, that's just not allowed. But what we can do is that if you do get sued, then there are things that you have put into place such that even if you did get sued, then you may not have to worry so much. And so this is what we call asset protection. And it's for especially for those who fall into any one of these categories. We'll talk about umbrella coverage for some people. We'll talk about setting up LLCs and corporations for some people. We can even do a certain type of trust called an irrevocable or irrevocable trust, depending on how people pronounce that. But there's different strategies that we can do for asset protection, and that's generally the kinds of stuff that would look like. Okay. Okay.
I just want to chime in because I know we also have some other sections we plan on covering. I actually got a question from someone watching with the question if should the spouse or the trust be the primary beneficiary of the assets, or does it matter?
So generally, if you're married in California, most of the time, and not all the time, but most of the time, the way we set it up is that both spouses are going to be the beneficiaries and both spouses are going to be the trustees initially. So what that means is while you're alive, if both spouses are the trustees while you're alive, you're able to actually go in and, you know, do things with your assets. You can withdraw money because you're listed as a trustee. You could sell your house because you're both listed as a trustee. As far as the beneficiaries go, that's usually, again, both spouses. And the reason is, it just means that if you're a beneficiary of your trust, you get to do what you want with your assets. There's no limitations on you. If we just made one spouse the beneficiary, that means the spouse that's not a beneficiary doesn't have access to those assets anymore. Mm-hmm. And the only time you really might see that is when we do some type of irrevocable trust planning. So for asset protection reasons, maybe it's important for somebody not to have access to their assets from an asset protection standpoint. But for people who are just creating the trust to avoid probate, you're going to be the trustee and the beneficiary, and both spouses would do that.
Mm-hmm. Okay, thanks for answering that.
Absolutely. So going back to, this asset protection, when we talk about entities, what type of entities we can create to give some asset protection, we're talking about LLCs, we're talking about corporations, and we're talking about irrevocable trusts. Now, these are like a very wide, diverse range of different tools that we can use. But these are tools that would be in my toolbox. So if somebody came to me and said, hey, I got a lot of rental properties, I want to make sure that if I got sued, that they can't come after my personal assets. What do I do? We might look at LLCs. In that example, we might look at LLCs. And if they have a lot of rentals, or if they have a lot of equity, or you combine it with the fact that they're a doctor and they're afraid that they might even get sued because of their profession, then we might even incorporate an irrevocable trust as well. So it's different tools that we bring in different ways and combinations. That's kind of the art that I do, is we look at people's scenarios and we say, okay, here's what's right for you. And we try to balance that with how much flexibility do you want versus how much protection do you want? Because sometimes those don't go hand in hand. If you want absolute total control and flexibility, you may lose some asset protection. And if you want absolute asset protection, then you may give up some types of flexibilities. So the art is, for me, is to always find the balance for people where they get just the right enough amount of control and still get the asset protection they want, okay? And I think you had, I know Letty, you and I have talked before about this, because some people have this question come up, which is that I have more than one LLC. I have more than one property. I have my primary residence where I live, but then I have a rental property.
Exactly.
And the question usually is, do I need to create an LLC for my rental property? And, again, if you ask me, the answer is yes. You should create an LLC for your rental property. To me, it's a no-brainer. It does cost more money. It does cost more money to maintain the LLC, but the trade-off that you get, I think, is enormous compared to if you just own it in your name. So I think a lot of people are aware of this, and they're really good about it. So I've seen a lot of clients that come to me already sometimes having an LLC established, which is great. It's good to see that they did that. But then what they do is they go, well, now I have the LLC, so I can put all my rentals in this one LLC. Like now I got a second rental, or I got a third rental. Now I can put all of those in that same LLC. And again, the problem with that is now you're opening up the risk on that LLC. So that if you did get sued by one property tenant, because you've held multiple properties in that LLC, that person that's suing you now is able to go after those other properties. Had you separated each rental out into its own separate LLC, then this LLC is not going to be affected by the other LLC getting sued. And that's kind of the one way to spread the risk, is to create multiple LLCs for multiple rental properties.
Okay, great.
Yeah.
Lily, sorry, I have a quick question that came up, and I know that we're kind of going a little bit further now into the business side of things and having multiple LLCs. So I just want to ask this question real quick, because it's a little more related to what we talked about earlier with trusts.
Yeah.
So the question was, are there any tax implications to consider when the transfers of the assets happens to a trust?
Yeah, so again, if the only reason we're creating a trust is to avoid probate, then the answer is no. So if we're only creating a trust to avoid probate, which again is something I think everyone who is a homeowner, or if you have more than 166,000, you have to create a trust to avoid probate in California.
Right.
So yes, once we create the trust, by moving the assets into the trust, no, there's not going to be any tax implications whatsoever. the reason for that is you are still going to use your social security number, even though those are going to be moved over into the trust. So the IRS, you don't have to file any separate tax returns for the trust. You don't have to report something special to the IRS. It's very, very easy. All you're doing is changing the title into the name of the trust, and that's it.
Okay. Okay, perfect. That's good to know. Thank you.
Yeah, that's a good question.
So I think we're going to dive in a little bit deeper into the ways of owning property, and if it's better to have it be like if it's a personal property versus a commercial property, and ways to own it.
Okay, great. Yeah, so it's kind of what we were touching on, which is that if it's a personal residence, if it's a home that you live in and that you occupy and it's not being rented at all, then the best way to own that is through your trust. Okay, so primary homes, you're going to want to own that through your trust. You do not want to put that in an LLC. I think there are some examples of that, but you really do not want to do that. The reason is you're going to lose a lot of the tax benefits that you have. And then there's also this requirement that you may need to pay rent, and you're going to end up not really getting anything special out of that at all. So primary residence, always going to keep in your trust. Now, rental properties, commercial properties, any other type of investment properties, at a minimum, you want to keep it in your trust. Okay, remember, the idea is you don't want it in your name. If it's in your name, it goes to probate. So at a minimum, you want to keep that in your trust. But I would recommend you take it a step further and create an LLC for that property, because you're also going to get asset protection. All right, that's what it's going to give you above your trust. It's going to give you asset protection.
Okay, perfect. I actually have another question coming right now, so I'm happy that we're getting all these questions.
Oh, good.
I'll point it out to you real quickly before we move on. It says, how should you protect your assets and kids taken care of in the event both parents pass away? I think we touched on that a little bit, but I don't know if you want to address it a little bit further.
Yeah, absolutely. So, and it's a good thing this has been recorded. So whoever's asking that can go back and look at the slides I shared about that. But yeah, absolutely. So the idea is you want to, if you've got kids, you're protecting yourself really from 2 or 3 things. One is, if I pass away, me and my spouse pass away, I want to make sure my kids are raised by people I want them to be raised by. We call this guardianship. Okay, this is nothing to do with my assets. Right now, we're just talking about who's going to raise my kids, what person is going to do that. So in your estate plan that the lawyer would do for you, we would name guardians for your kids. And we shared the slides about that, and you can look back at that and see what are the different ways we can name guardians for your kids. But that's number 1. Number 2 is we want to make sure that our assets don't go into probate when we die. Because if they go into probate, it's going to take a few years maybe to get them back out. And our kids aren't going to get it until they're 18, and that's not good for a lot of reasons.
Exactly.
So what we are going to do there, again, is we're going to create a trust, and we're going to move our assets into the name of the trust while we're alive. And what that's going to do is it's going to make sure that when we do pass away, those assets are not going to go to probate. Instead, they're going to be able to be controlled by someone we call trustees after us, and those trustees have access to it for our kids until our kids turn older. So all of this keeps it out of court.
Okay, perfect. And I know we kind of like jumped to the ownership of property section as well. I have a question from someone coming in asking, what if you are owner occupying the primary residence and you rent out an ADU or any other units on the property? Do you recommend setting up an LLC as well in that case?
It's a really good question. And I think the difference
happens a lot right now.
Absolutely, yeah. And I think the difference is, I can think of different examples for different people. For example, you can have an example where, let's say you have a duplex, and in the duplex, you're actually occupying one of the units, and the other unit is being rented. Right. Now, in that scenario, if you're trying to maintain the tax benefits of making sure that you have a primary unit, In other words, if I sell my property, one of the benefits of keeping it in my name is when I sell it, I have, the 121 exclusions, right? So I can do a $250,000 write-off against the gains. If I'm married, it's $500,000 against the gains. If I want to take advantage of that, then it's better not to put it in an LLC. Okay. Now, if I don't care about that for some reason, maybe I have another primary residence,
Right.
and this is more or less a purely rental, but I'm occupying it because I have to, because of the terms of my loan, let's say. You can put that in an LLC if you're occupying it. That's fine. But I think it comes down to what you want to achieve. If you're trying to take advantage of the tax benefits that the IRS gives you, then you keep it in your name. If you're trying to take advantage of the asset protection benefits, then you put it in an LLC.
Got it. Okay. That's good to know. And I have the feeling we're going to get some more questions as we go on, and you're probably going to get some calls afterwards.
No, that's fine. And it's interesting because, this is a time period, unfortunately, where this has now been on everyone's radar. And so I'm glad you suggested that this was a topic of conversation that people found interesting, because now more than ever, we realize just, icebergs are everywhere, to use my analogy from before. And we all used to think, oh, it's, I'm young and I have time and all that. Now people starting to realize, like, look, anything can happen. We don't want to take things for granted. I want to make sure I protect my home, protect my family, and keep my house in order. And that's the right way it should be. The good part about this is, in some weird way, we have time. We're home now. We can make some decisions. Not to say we're not busy, but in some ways it's become a little bit easier for folks to communicate and get this done now that maybe both husband and wife are at home. So I always try to stay on the positive end of it, but happy to answer questions.
No, I mean, I have the same thing. It's something that a lot of people I think want to do and plan for. But then the reality of it is that it's not really a fun subject to deal with. Like, okay, what's going to happen should I pass away, and how my assets are going to be divided, and what's going to happen with my children, or things that you build up. So I think that for a lot of people, it's not the easiest thing to actually, make time for. So thank you for making it, somewhat easier.
No, I'm happy to. And I know people know this. I know everybody knows this. Like, nobody has to be told that, but it's important to hear it again. And so when people say, yeah, it's not a very fun subject, or, I don't want to think about it.
Exactly.
The reality is, if you don't think about it now, your family is going to end up having to clean up a big, big mess, and they would have wished you had done it. And I was actually on a call this morning with someone who shared with me his experience. He was an accountant. He's a CPA. And he was sharing with everyone on the call a story where he had a client whose parents did not do any estate planning. And one of the things that people will face if you don't do proper estate planning is you're going to pay a lot of money in taxes, you're going to lose control of a lot of your assets, you're going to deal with a probate. Well, this CPA was dealing with this couple's aftermath, the mess. He was trying to clean it up. And he shared with us a quote, which I jotted down here. And I mean, it's almost comical, but not so funny if it happens to you. He said that when the son was leaving his office, he was like, man, what a mess. I wish my parents had taken care of this. The son was leaving the office, and he was just so, depressed. He turned around, looked at the accountant, and he said, now I know what to do the next time my parents die. He said, now I know what I'll do the next time my parents die. I mean, right? So you only get one shot at this. And that's what I think people need to understand is it's on you to do it. If you don't do it, it's going to be a big, big mess, more expensive, more money for the lawyers, more money for the government. And it can totally be avoided, right? So very important to keep that in mind.
And I feel like also everyone has some assets, like even if you're not owning a property, you have kids that you have to make arrangements for. If you don't have that, you might have a business, or you might have, really good chunk of amount in 401k savings. And so in every aspect, there needs to be something in writing that protects those assets in whatever way or shape.
Absolutely right. And not to forget the incapacity documents. I mean, that has nothing to do with how many assets you own. If you're I have parents who see the wisdom of this. I had a client, just recently whose daughter turned 18 and she went off to college. And he said, I need to do an estate plan for my daughter. And I said, what do you mean? And he said, well, I'm not talking about a trust. She doesn't have any assets. I'm saying she needs to create a power of attorney. She needs to create a healthcare directive, because if something happens to my daughter and she's incapacitated, and if she doesn't name who can make decisions for her, like her parents or family, somebody's going to have to go to court for her and help make decisions for her. So it's something that really, really affects literally everyone. It's just that not everybody needs the same thing.
Yeah, no, that makes sense. Okay, I'm gonna ask one more question.
Sure.
Another question just came in. And this is a little bit more about investment property. If someone were to purchase an investment property, would they put that in their already existing S Corp, or would you suggest an LLC?
I can't answer that question without more information. And I know that sounds like a lawyerly answer, but that's the correct answer, because if anybody can listen to that and give you an answer, then that's not good advice. It depends on the business. It depends on what we want as far as the tax benefits down the line. For example, if it's a rental property, one of the really good features of an LLC for a rental property is that when you die, you get something called a step up in basis. That's not there for a corporation. On the flip side, maybe you want to set it up as a corporation because you're going to have employees. Maybe you don't want to be hit by the self-employment tax. So there are very unique tax features that make a corporation and LLC entirely different. Sometimes it depends on the industry that you're in. Sometimes it just depends on the type of business that you have. But there was a little hint to that question, I think. If you have an existing entity already set up, my guess is you have an existing entity set up for some type of business you're doing. The idea that you would somehow put a new business of any kind into a existing entity of any kind, probably not a good idea.
Well, this is an investment property. So what I'm seeing with most of my clients, without giving a straight answer, and definitely, whoever's asking this, and I can connect you with her later. You have to know the bigger situation, of course, but in general, what I'm seeing is that people put one LLC per property to keep it separate and to keep it protected from other assets you have, whereas you would combine it into already existing S Corp. So I think that's what I've seen. Of course, I can't say if that's the correct route to go, but that's the majority of people I've seen to do it.
Yes, and that's right. So if it's an investment property, again, and I think we've covered it, if it's an investment property, you want to make sure you put it in its own entity, the reasons you exactly said. And it's important to get the terminology right too. So sometimes an LLC can be taxed as an S Corp. So when someone says I have an existing S Corp, I want to know, first of all, is it a corporation taxed as an S corporation, or is it an LLC taxed as an S corporation, right? But going back to your earlier point, generally speaking, you get new investments, you want to partition that on its own.
Yeah, I have investors that do flips, and every single property they buy, there's a new LLC. Because there's, they pull together money, group investors, and there's just, it gets confusing in many ways. So
exactly right. And it's also unique to how it's being taxed. So you could have a rental, for example, that's in an LLC, but for the things that you're trying to achieve, you're going to tax it as a partnership. And then you can have a situation where you have an investment property also in an LLC, but because of its unique, what you're trying to achieve, it's taxed as an S Corp. So very, very important to make sure this cookie cutter stuff is really, really dangerous. Anybody who's offering any type of advice like that is really not seeing all of the options. And that's why they think that, I can limit it into some cookie cutter offering, which you will appreciate as the client because it's easier for you to understand, true, but you're missing out on options and opportunities if you're not looking outside the box.
Yeah, no, I agree. Well, I'm just keeping an eye on our Facebook Live and seeing if there's more questions coming up, but I think for right now, we're good. Okay. Do we want to go in a little bit more. I don't know if we've covered the difference. We did go into LLCs and properties. What's the difference between a revocable trust and an irrevocable trust?
Yeah, it's a great question. You know what I'm going to do is I'm going to actually pull up one of my slides here to see
Yeah.
If this will make more sense for people. Oops. Okay. Sorry about that, Letty. I'm gonna find that slide in just a minute. But here we go. So let's put up this slide about how a trust works. So if you remember before, we were talking about the grantor, the trustee, and the beneficiary.
Right.
And what I had said earlier is that when you create a trust, you are the grantor, you are the trustee, and you are the beneficiary. If you're a married couple, then both of you are all of these people. And this is what we call a living trust. So it's also called a revocable trust, right? A revocable trust is the same as a revocable living trust. The idea is in a revocable trust, because you are the trustee and you are the beneficiary, you have total control over your assets. You can sell and do things, and it's very easy, no tax returns. It's the simplest thing. An irrevocable trust is where you start to change this model up. It's where you say that I'm putting my toys into the wagon.
Right.
I'm the grantor. I'm putting my toys, my house, my assets into the trust, the wagon. But I am not going to control the wagon. I'm not the trustee. I'm giving the handle over to somebody else. And that person is in control of my trust now. They're going to pull my trust. And I'm not going to be the beneficiary. Meaning, once I put my toys into my wagon, someone else, maybe my kids, my spouse, are going to be the beneficiaries. They're going to be able to pull out the assets when the time is right. So the idea with an irrevocable trust is I'm putting in my assets into a trust and I'm giving up control over the handle. I'm not the trustee. I'm giving up control over my toys. I'm not the beneficiary. And this is why people say irrevocable means you can't change it, because it's a gift. Once you're giving it to this trust, it's out of you. It's out of your property now. Now it's not yours anymore. Now when you get sued and someone says, hey, I want that Barbie doll, that $10 million, $2 million, $1 million home, whatever it is, I get to legitimately say, I don't have it anymore. I gave it to this trust. I don't own that. I don't control that trust. I'm not the trustee, and I'm not the beneficiary. So it's not mine anymore. That's the idea behind an irrevocable trust. Now, many people will ask this question, say, okay, I get that, but why would you give up control of your assets? Well, two ways to answer that. One is you have to. In order to get asset protection, you really have to give up that control. If you don't give up that control, then the person suing you is going to say, wait, you have access to it. You're the trustee. You can reach in and pull that out. You're the beneficiary. So number one is, if you want the asset protection, you have to give up some of that control. But I think the second way to answer that is to let people know it's not that you're giving up complete control, that you can't use the assets. There are still ways that we can have you use it. There are still ways for your family to use it. There are still ways for you to, maybe even get income from it. So irrevocable trust planning is rather complex because, again, it's the balancing act. We want to make sure we get the asset protection, but we still want to get use of the toys maybe in our lifetime. So it's achievable. It is achievable, but that's part of why you need to really sit down and plan that. And I usually tell people, irrevocable trusts are not for everyone. It's for people who have a need for it. It's for people where the cost benefit makes sense. But for most people, they just need a living trust where they're totally in charge of everything. They get to do whatever they want at any time. They can make changes during their lifetime. For most folks, that's good enough. It's just that you're not going to get the asset protection out of this, which is why LLCs are so important, because at least the LLC will give you that protection.
That's true. That's true. Okay, thanks for clarifying that.
Yeah.
And, talking more about, asset protection, which I know you touched on right now, what are some more advanced asset protection strategies that are more specific towards real estate?
So, and I do have a slide for this. So
I figured you
sorry,
would.
sorry about this. I'm a visual learner. I've always have been, and
Well, honestly, I find it very helpful too, and I think that some of these things, this clarifies a lot of ways of how things are actually divvied up, and makes for
yeah,
me, it makes it a little bit easier to understand, because
yeah,
this is not my specialty either, so I'm learning as much as everyone else is learning right now.
right. No, no, no. I'm my job really is not just to do what people are looking to do, but also to try to find ways to explain it,
Yeah.
because it does get kind of complex. So,
Yes.
but you asked a very good question. What are some more advanced strategies if you have real estate or other assets? So again, I'm just identifying tools that are in my toolbox. So LLCs and corporations, that I consider a minimum. That's
Right.
why I don't even consider that to be advanced. I mean, everyone should just understand that and get past that and just get to it.
Mhm.
But if you wanted to go a step further, there are things called, we talked about irrevocable trusts, where you put it in a trust and you give up control. That's a very useful tool. I mean, that's a tool that we use a lot in the advanced category. There's also something called residential land trusts. So these are really neat. It's for your home. So people say, look, I got a lot of equity in my home, Lalit. If I get sued, I don't want someone to take the equity out of my home.
Right.
What can I do to protect my home? Because I can't put it in an LLC. I need to put it in my name to get the tax benefits. So is there something I can do? So there's this really neat thing we call land trusts. And in California, there's a kind of a unique way to do it. And again, this is one of the tools that I will use specifically for residences,
Right.
where you don't give up, you don't lose the tax,
Mhm.
you still keep the tax benefits of having it in your name. You're avoiding probate, and we're still able to build in some asset protection that may possibly protect your equity.
Right.
And that's a really, really popular thing that a lot of folks are starting to do more and more of.
Mhm.
You'll also see land trusts being done in situations where you have a first-time buyer of a property where they want to keep their name off of public record.
Mhm.
I've done that for many clients who, either for public safety reasons or because they're more well-known and prominent, they want to keep their names off the books, the public books. So land trusts are really useful there. And then of course, there's something called equity stripping, where we will basically take equity out of the property and find ways to protect that equity. Because if you don't have the equity in the property, it's really not very valuable to your creditors at that point.
Right.
And then, we can go further with some folks where we do something called an asset protection trust. It's a type of irrevocable trust. And we can build those in the country. We can even build those out of the country if we want to get to really higher level types of asset protection. So there's, there's a lot of things that we think about when we do that. Which state are we going to use to do that? Because there's some states are better than others. This is no secret, but as you can probably imagine, California is not the best state for asset protection. So
Mhm.
where we can, we will build asset protection trusts out of California, because we will get a lot more bang for our buck, so to speak. And people will do this for real estate, but they'll do it for all kinds of investments, whether it's to protect themselves from a lawsuit or even a divorce. You may have heard like prenups. Like, let's say somebody does a prenup in California. Well, your prenup may not hold water. It may not be very well done, or the law may change in California where it's not enforced, or you may not have updated it. So there's things that you could do through trusts where we can protect your assets from divorce. But it goes beyond that, as you can see here, lawsuits and bankruptcy even, and
Right.
creditors, all of that. So all of that is at our disposal. Again, it's not for everybody, but for those who need it, it's absolutely possible to do these things.
Okay, great. Thank you for sharing that.
Yeah, absolutely.
Awesome. I love that you left. You can leave the last slide up for a little bit too if you want.
Oh no, it's okay.
Anyone can take a note. But yeah, like I said, we are going to be sending out, a copy of this recording to everyone. I'll make sure to include Lalit's information as well, because I do think there might be some follow-up questions people might have. And I'm happy we kind of kept it to an hour, so it's good timing.
Yeah, we're right on time. Perfect.
Do you have like a closing note or anything that you want to leave with people as we finish up?
Yeah, just to reiterate again, I really am a very, very big advocate of educating my clients. I know folks who have done their estate planning, they've already done it with someone else, and I've seen mistakes being made a lot of times. I see stories that, I have a trust and I just need to look at, I just need you to look at something real quick. And 5 minutes into the conversation, it's very apparent that they actually have no idea how this trust was set up,
Yeah.
and that their assets are still held in their name. And I'm saying, why are your assets held in your name if you have created a trust? And
Right.
they don't understand it. And so my job as an attorney, and I feel very strongly about this, even with our partners at our firm, our associates and our staff, is that everyone is really big on this idea that we want everyone to know how this works. Because if you as the client understand these concepts,
Right.
then not only is it more likely to work for you, but then you can also help your family. Because the thing I always tell people is, this is a selfish way of thinking about it, but if I pass away, I'm not there to deal with the aftermath. It's my family that's dealing with the aftermath. But similarly, if your family members, something happens to them, you're the one that's going to have to clean up that mess.
Yeah.
So it's a two-way street, and you really, really need to understand that. It's not just planning for yourself. It's make sure the loved ones around you are planned for, so that nobody has to go through this, right?
Yeah, likewise. Good. Well, I started the process with you. I'm inspired to like get to the finish line with all my paperwork that I need to send over to you. So thank you. This was extremely helpful. And thank you for taking the time to go over everything with us.
Thank you, thank you for having me, and thanks for doing this. And I think it's a great resource you're doing with these educational talks. People can use that, especially now.
Yeah, and I think there is a lot of good information out there, but I'm just trying to stick to the topics that I find very interesting as well, and what I think could be of benefit to others. On that note, a really quick note: what we're going to do in the next few weeks, we are going to have a company that creates ADUs in the backyard speak, because I think that's also the topic where I get a lot of questions about, and it's real estate related. And then we have a 1031 exchange facilitator join us, which basically is tax deferred exchanges when you have investment properties. So we're going to dive in deeper in that as well, and talk a little bit more about the 1031 exchanges, and probably more topics to come. But thank you all for joining. And again, thanks Lalit, and we'll speak soon. Thank you guys.
Thank you.
Thank you.